Good morning. Lesson 2 today. I posted the slides online earlier in the week. I have gotten a GoPro, so now we don't need the software to run the recording on a computer. So that will simplify this process immensely. Took me longer to get the GoPro set up and figured out than I thought, but here we go. So today we're going to pick up with lesson 2. We're going to start on page 17 of your book, and we're going to follow this scenario in the book basically just to learn some basic courtroom proceeding terminology before we move on to the case studies and treaties and such. So in this scenario, we have Doug, who is the defendant, and Pete is the plaintiff. The defendant is an individual, company, or institution sued or accused in a court of law. So this is the guy who is perceived to have done something wrong or owes someone something else. The plaintiff is the person who is upset and is attempting to use the court to get compensated in a civil case for this situation. So Pete is taxiing and Doug was in the way. Pete had to take evasive action. His aircraft hit the hangar and he went to the hospital, and now he has about $80,000 worth of damage. So Pete and Doug fought over it and no resolution. They weren't able to come to a resolution. So now Pete is going to sue Doug, and we're going to follow that scenario. So on page 18, figure 1-5 shows the initial complaint, which is basically the start of the lawsuit. And it establishes why Pete has the ability to sue Doug in a court of law. So essentially, he's going to type up this document with all the reasons and evidence, and this document can be many, many pages long. This one in the book is only like a paragraph just for simplicity, but the book uses the example of hundreds of pages for a typical complaint to establish the legality and all of the things that are going to be discussed during the case. It's also going to outline specifically what the plaintiff is seeking. So it's going to be a detailed list of, you're going to pay to fix my airplane, you're going to pay for my medical costs, you're going to pay for this and that, and the list goes on. So it's going to be very defined. All right. The summons is the next step. It's a notification to the defendant that a complaint or lawsuit has been filed against them. So on figure 1-6 on page 19, it's going to tell us, Doug, this is his address in Dorchester, Delaware. You're hereby summoned to file a written response by pleading or motion in the court to the attached complaint filed by Pete, the plaintiff, within 30 days of the summons against you. So basically, it's notification that someone has evidence that you owe them money or have committed an action that has caused damage, and they are coming after you in the court of law. So basically, if you fail to respond at all, he can immediately be paid because you basically didn't fight it, and therefore you're admitting wrongdoing or guilt. So you have to reply to the summons if you don't want to basically have a settlement be judged against you for the whole amount of the complaint. These can be delivered in many different ways. Some can be delivered by certified mail, depending on the type of case. The sheriff can serve you, bring you your court papers, and tell you, you're being served. Or the law firm can pay a private contractor to show up at your residence or your address or even your work and serve you your paperwork. I put some links online of a local serving service in Duluth that actually does this. Just kind of for some local awareness that these people are walking around every day and handing out lawsuit paperwork. Just kind of interesting. So once this process has been complete, obviously you have 30 days to reply once you have been served, but there are individuals who have incorrect contact information or they are trying to evade being served, they'll move states, disappear. Basically, as long as they're not served, the lawsuit kind of just hangs out there and is unsolved because they can't give a judgment against you unless you have been notified that you have been that you're being sued. So, all right. So once the defendant or the wrongdoer has been served, he must decide how he's going to handle the situation. Often, if someone showed up today and walked up to my front door and told me I was being sued for $30,000 for something, I would immediately go find myself a lawyer because it's going to cost you a lot more potentially in the end, maybe not, but I don't know that much about it, and if I was being sued for a lot of money, I would go and make an effort to speak to someone who it's their job to help me. So, possible answers. Doug can basically admit that he was the cause of this incident, and he can have a judgment placed against him, and now he has to pay Pete. Or he can respond and say, no, you did this on your own, and I did not do this, and I'm not going to pay. And then it's going to go back into Pete's court. So what we see in figure 1-7 on page 20 is that Pete says, look, man, for number one, he admitted that he's a resident of the state of Delaware. And then number two, he says that he has insufficient information to admit or deny this charge. And number three and number four, he says, no, I didn't do that. I did not cause $50,000 and $80,000 worth of damage. So good luck. We'll see you in court, basically, is his sentiment. So obviously, if you go to court, you're going to incur costs and lawyers and all of these things, but if he doesn't, then he's going to have a judgment for $130,000, which is a significant amount of money. So he basically needs to just review his situation and with his lawyer and decide if he's going to admit to it or deny it. And of course, here we see that in the case of the scenario, it was denied. So then he's going to build a defense. So an affirmative defense basically is Doug's building a case that he's not responsible for anything that has happened because Pete caused the damage by being negligent. And he can come up with supporting information as far as why that is the case. Commonly, when people get into a litigation like this, there's what's called a counterclaim. So a counterclaim is essentially when Pete sues Doug and says, you owe me this amount of money for my plane and my medical expenses. Doug says, well, actually, I had damage on my airplane as well, but I haven't brought it up yet, and here's the document of maybe a small amount of wingtip damage or something of that matter. And he would say, well, I already paid to have it fixed, but since you're going to sue me, well, now I'm going to counter sue you because I want to be compensated for the things that I just wasn't going to worry about because it wasn't big enough to take to court. But now that we're going to court anyway, I'm going to counterclaim you for this amount of money that I'm dealing with. So this can be common anytime that litigation happens. A lot of times counterclaims can have to do with loss of use of aircraft, being that like you took an aircraft in for maintenance and it stayed there for 6 weeks longer than the maintenance facility had told you, and then you didn't make enough money to end up paying for the aircraft because it was sitting there for 6 weeks longer and not making any money. So now the mechanic shop, the 145 repair station, might sue you as an operator because you haven't paid them for the maintenance that was done. But then you can countersue them, stating that you were going to pay them the amount that you were going to pay them to have the aircraft done 6 weeks sooner, and you would have been able to pay them, but instead you had loss of use of the aircraft because they failed to fix it in a timely manner. And now you have to be able to prove, hey, I could have paid you, I shouldn't have to pay you the full amount because you took 6 weeks longer, which cost me this much money. So we see things get very messy very quickly once people start litigating, and we have this situation of basically going back and forth and suing each other. So we have the pre-trial phase, which is basically once we have decided how we're going to defend ourselves, if we're going to do a counterclaim. This phase starts once the complaint, the answer, and the counterclaim are done. The things that are important to understand during this whole process is that if during this process the party decides that they want to settle this without going to court, they have the ability to peek and go and say, look, if you just pay me this amount of what I'm claiming, we can call it good. Or if Doug says, you know, I feel like I'm responsible for this part of what happened and not that, so I will offer you half of what you're asking for. And Pete may say, well, at that point it's worth it to take the money and not go through the legal proceedings, or he may not.